Hello, everyone, and welcome to this Privacy Rules Privacy Espresso episode. My name is Alessandro Di Mattia, Legal and Executive Officer at Privacy Rules. And the Privacy Espresso series is a series for which we discuss recent news and the most relevant topics related to privacy and data protection with global experts in the sector coming from the Privacy Rules Alliance or guest speaker. Today we are going to discuss about a very recent case that comes from the French DPA, the Cnil, and that regards the cookie consent flow for TikTok. And we are going to do so with the Privacy Rules member expert from France, that is Jean-Christophe Chevalier from the French law firm HIDE. Jean-Christophe is partner of the firm and also one of the main experts of the data privacy team. And for this reason, I'm particularly pleased to have him with us today. So Jean-Christophe, thanks a lot for joining us and welcome to this Privacy Espresso.
Thanks a lot, Alessandro, and thanks to everyone for the audience.
Great. And let's start with this Privacy Espresso. So let's start with the classical broad question. So what happened? What's the case about?
As you mentioned it, the case is clearly about cookie consent. In fact, between May 21 and June 22, the Cnil carried out several online investigations on the TikTok website and because of documents requested from the company by the Cnil. The investigation was made in an unlogged session and exclusively on the TikTok website, and the CNIL considered that there was a huge lack of transparency on the different purposes of the cookies set up into the website.
Perfect. Thanks for the brief introduction, Jean-Christophe. And as we know, the CNIL issued a fine to TikTok. So can you explain us which were the reason of this fine?
Yeah, the reason of the fine is that TikTok had failed to comply with the obligation set out under the Article 82 of the French Data Protection Act, which relates to the right for any data subject to be clearly and transparently informed about the purposes of their personal data processing and the means put in place by the data controller. Therefore, they were not able to consent and or to refuse to the processing of their personal data for specific purposes. Additionally, the CNIL claimed that the cookie banner was discouraging users from refusing cookies. The outcome of the investigation noted that several clicks were necessary to refuse the cookies, and make the experience of the web user more difficult, and they were not in position to refuse their agreement and not to consent to the cookies, which is clearly in contradiction with the regulation.
Wonderful, Jean-Christophe. That's very interesting. And still in relation to the fine, we understand that the amount of the fine was also depending on some previous reasons from the interaction between the CNIL and TikTok or companies similar to TikTok. So can you delve a bit more also into this?
Yeah, the main reason of this is that, first of all, the breaches that have been identified for sure, but the number of data subjects and the fact that there was some minors. And so numerous, and again, before setting up a fine, the CNIL always discuss and exchange and request from the data controller to comply. And there was numerous communication between the CNIL and TikTok, and based on this and based on the fact that TikTok did not fully comply and did not take any enough commitment, the decision was rendered and the fine were pronounced.
Thanks a lot, Jean-Christophe. Thanks a lot. So we have a clear understanding of the reason behind the fine, and this is definitely related to the main type of tracking technology that or the most known type of tracking technologies, that is cookies. But I think that it would be interesting not only for me but for our audience as well to know if this position of the CNIL should be related only to cookies or to any other type of tracking technology. So if we should, in another way, consider this as a decision not just related to cookies, but to tracking technologies in general.
As a matter of fact, this decision only relates to cookies, but it can be expanded to tracking technology because it clearly demonstrates that any kind of tracking technology, such as cookies or any other type, with specific purposes, such as advertising as well, have to be clearly identified as technical measure used by any data controller, because they cannot be put in place without the express written, not written, but the opt-in of the data subject. Therefore, the answer is that any website publisher, any social network publisher, any online gaming platform editor, and more generally, any operator that are using tracking technology to promote their activities and how to promote third-party services and how to target data subjects, have to make sure that their privacy policy are fully transparent, and in the context of cookies, the cookie consent managing system is clearly and transparent enough.
That's key. So thanks a lot, Jean-Christophe, also for providing us with more detail and a broader perspective and value of this decision. To expand it even more, my next question is related to the ad tech sector that has been severely impacted by the decision, not only this decision of the Cnil, but in general other decisions that we have witnessed in the last weeks. So how much this decision as well impacts on the ad tech sector, in your view?
Actually, we were completely aware that the Cnil was increasingly attentive to the practices of companies in the advertising industry. And because, I mean, there was the decision with Meta in Ireland, that decision against Google, decision against TikTok, and so on. And now we completely understand that the CNIL will never, and we no longer tolerate any non-compliance with the French Data Protection Act in this sector. And this decision is clearly a step towards to the voodoo decision rendered on December 29th, but published on January 17th, 2023, where the CNIL fined the mobile game publisher Voodoo 3 million euros for using essential technical user identification devices for advertising purpose without the prior consent from the users. And on other aspects, there is also an issue with the fact that we have some minors, but clearly the impact is very strong on the ad tech sector.
Perfect, Jean-Christophe. Thanks a lot. And it's clear that Cnil is no joke when we speak about consent in particular. And this decision that you mentioned, and thanks for doing that, about the Voodoo case, sounds even closer to the one we heard in relation to the Irish DPA and the position against Meta. So there seems to be some sort of alignment between the various authorities at the EU level on this topic, and I can understand that this is also because this is really part of the core of the privacy and data protection and the individuals' rights. So I can understand the reasons behind this. But I would like to, Jean-Christophe, I would like to thank you very much for being with us today and for your quick but clear explanation on the TikTok case by the Cnil. And I would like also to thank our listeners for being with us today and for following the Privacy Espresso series. Looking forward to meet you and all of them, of course, in our next Privacy Espresso episode. So bye everyone for this week. See you next week.
Thank you, everybody, and Happy New Year.